The law is not a blunt instrument for distraction, but the scalpel for the precise protection of rights. Those were the words of Justice Kate O'Regan. The law is not there to make political noise. It is there to solve problems with precision. And when it comes to farm schools, the law already gives us the scalpel we need. Farm schools have a history rooted in cooperation. Many began as an arrangement between farmers and communities long before the Department of Education ever existed in its current form. And today, those schools stand as public institutions on private land, and their security depends on proper arrangements between the state and the landowners. Honorable MEC, I'm happy that you brought a very practical example. Honorable Dabampe, in his speech, he made reference to white farmers or white farm owners a number of times. I don't know who told EFF that every time when you mention a farm owner, it is a white person. Because farm owners can also be black people. And the example that the MEC gave of the former EFF member of this legislature, Honorable Lebogang Kaba, is a very relevant one. Actually, MEC, the name of the school is Modisa Dinku Primary School, where the arrangement is that the education department provides teachers with curriculum, resources, while the farm owner, who is a black person, by the way, a member of the EFF, by the way, provides or assists with water when there's challenges and even gets in touch with the department every time when there are issues. What I think should have done is to come up with specifics where there are issues and requested the MEC to intervene in terms of the law. Which law? The South African Schools Act, Section 14, because it makes it a legal requirement that where a public school operates on private property, there must be a written agreement. This agreement is not a courtesy, it is a condition for lawful occupation. And when you go further, Section 58 goes further. It says when negotiations break down, if there's such an incident, the MEC has the constitutional power to expropriate the land, or more appropriately, a real right of use to that land, so that the school can continue operating. And in doing so, the MEC must comply with the Constitution's standard of just and equitable compensation. This is not a new law. That is not a radical law. It is existing law, tested and upheld. Honorable Speaker, the Constitutional Court in Juma Masjid Primary School versus SA was crystal clear. The state bears a positive obligation to ensure that learners' rights to a basic education are not disrupted. But that obligation must be balanced against the landowner's constitutional right to property under Section 25. It is this balance that defines the constitutional order, not political expediency that the EFF has brought today. We have so many precedents that the EFF can use, including the governing body of Juma versus MEC of Education KwaZulu-Natal, where the court emphasized that eviction of a school is not an ordinary property dispute. It is one that engages the rights of children and triggers a higher duty of care from the state. In that case, the court underscored that if the state fails to take reasonable measures to secure alternative arrangements, it will be in breach of its constitutional duty. What do these cases tell us? They tell us that the law already equips us to deal with any genuine threat to the operation of a farm school, without trampling on property rights and without disregarding the Constitution and without resorting to political theater. Now the EFF has brought this debate to the House. That is their right. But debates of this nature are most meaningful when grounded in real current evidence of a problem. If there are farm schools in the Northwest today under threat because Section 14 agreements have lapsed and negotiations have failed, we should deal with those cases head on. And if necessary, we must request the MEC to invoke Section 58. But without such evidence, it would be irresponsible to treat this situation as a province-wide crisis. The DA's position is consistent. Protect learners' rights to education, protect owners' property rights, use existing legal mechanisms, not political slogans, to secure schools. Reject expropriation without compensation, but accept just and equitable expropriation of a limited real right when negotiations fail and children's education is at risk. As part of our oversight function, we will request the MEC of Education, together with the MEC of Public Works and Roads, to provide a list of all public schools situated located on private land in this province, the existence and expiry dates of all Section 14 agreements, details of any disputes, lapses, threatened evictions in the past 5 years, and the department's responses, as well as any instances where Section 58 has been used. This information will allow us to see whether there are in fact problems areas in the Northwest and to act when needed. Oversight is not about waiting for a crisis. It's about making sure one never arrives. Honorable Deputy Speaker, I stand here not to dramatize but to deliberate, not to call for a blunt force but for measured action grounded in law. For learners in farm schools, predictability is everything. For the landowners, security of rights is everything. And our duty is to give both. And that's, Honorable Deputy Speaker, is how we govern within the Constitution, not outside it. True justice is one that uplifts communities. True justice protects the livelihoods and builds partnerships. It even protects the rights of farm owners like Honorable Gaba, the former honorable member, who used his pensions to buy his farm, that today his own party say must be expropriated. For what good? What is it that you are having against that man that you'd even come and propose a debate against him when he's doing quite well, when there's no crisis? I never expected this.